we have a couple of new things that have populated on the Idaho Judicial Branch website. Now, this website here has everything in the Bryan Kohberger case, all of the documents that have been filed, the orders for sealed items, the orders for wishing for something to be sealed, the orders granting sealed items, and such, right? Now, the first thing I want to mention is, well, I noticed that it says here that there are two new documents, and one of them being an April 29, 2025, and it says order defendants motion to strike the death penalty and adopt new necessary procedures. And when I clicked on it, I was like, we already talked about this. This isn't new. This isn't part of this notice of a hearing sealed. And I went back and looked to see if maybe perhaps there was another document that was put out there, because it just didn't look right. And one thing that I noticed here is on April 28, 2025, there was a defendant's notice of compliance. Now, that wasn't there the last time we talked, when we talked about Dr. Ramsden. This is before she responded. This is when we initially looked into the airmail article by Howard Bloom and his theory into the motive of Bryan Kohberger. And before we got into that conversation, we looked at the new documents that were out there. The order sealing the state's motion examination pursuant to IC 18-207 was there. The order of the defendant's motion to strike the death penalty and adapt necessary procedures was there. And those were on the April 29th. April 25th, the motion to seal the motion for examination pursuant to IC 18-207 was also there. But what wasn't there was the defendant's notice of compliance. Nothing weird, nothing strange. It's just that it just kind of popped out of order. And, they put that there. So what this tells me is I'm probably going to spend the next couple of days going through and seeing if there's anything else within the last almost 3 years now, if anything else is populated and put in that wasn't there when we first went through it in order. Because this is something that just recently popped out. And the only reason I caught it was because of the fact that there was an issue here when it comes to the order in which they kept on a order for the defendant's motion to strike as a new order, and it just seemed wrong. And so let's look at what that order is, though, real quick. The defendant's notice of compliance comes now. Bryan Kohberger and submits to the court his notice that the defense has hand-delivered an external hard drive containing their exhibits and proposed exhibit list to Latah County Prosecutor Office pursuant to the court's unredacted seal order governing further criminal proceedings and notice of trial filed October 9, 2024. And so the defense has hand-delivered some sort of external hard drive containing all of their exhibits and their case basically to the prosecution. Now, this is something that happens in every case, and this is leading up to trial. So, I think that basically when it comes down to something like this tells me this is going to be on August 11th. It's going to start. I don't foresee anything delaying this at all whatsoever. Interesting thing that popped up. Now, the next thing that I noticed is that there's a notice for a hearing here. And this is a notice of a sealed hearing. This will be on May 5th, 2025 at 11:30 a.m. This is, I believe, 8 a time. I'm not sure what it is, if they do the whole daylight savings time, if they bounce back and forth, but I think they're about an hour different than what I am here in Central. And so this will be about 12:30, but this is going to be sealed. This is a remote hearing, and invitations will be sent out. Now, a lot of people were looking at this. Some people were thinking that this could be a plea deal. Some people were thinking a bunch of different stuff. Now, for those that have watched onto the show would know that exactly what this is. We talked about what this hearing will be. I did say expect an ex parte hearing. I think I said that not in the last show, but the one before that. And what that was referencing was this order here. This is the order sealing the state's motion for examination pursuant of the defendant pursuant to Idaho Code 18207 and for extension of time to complete rebuttal penalty phase expert disclosures and declarations and exhibit supports. This is a document that was dropped, I want to say the 29th of April. So it says here, based on the state's motion to seal the state's motion for examination of the defendant, and this is for the state to get a impartial, or, well, I don't know if you can call it impartial because this is, I guess, a state's witness. The state wants to get a doctor to evaluate Bryan Kohberger. And the state's motion to seal is the examination of the defendant. And the second part of this, it says here, and for the reasons stated in the motion, and until a hearing can be held on the matter. So it's sealed until, because of the reasons stated in the motion, that based on the psychological examination that they're going to give Bryan Kohberger, they're going to keep that sealed. So now they talk about a hearing that can be held on the matter. Now we have a sealed hearing. It doesn't necessarily mean they're two in the same, but I don't believe in coincidences. They're specifically talking about a sealed hearing, and now we have one, and it's referencing the state wanting to look at Bryan Kohberger. We can go back to this document here, and this is the motion to seal the state's motion for examination of the defendant pursuant to Idaho Code 18207. And on this document here, it says, here comes now the state of Idaho, and they hereby move the court to pursuant to Idaho Court Administrative Rule 32 and Idaho Code 74-124B for an order sealing the state's motion for examination of the defendant pursuant to Idaho Code for an extension of time to complete rebuttal penalty phase expert disclosures as well as declarations provided in support of this motion. The motion declarations and accompanying exhibits reveal personal, private information of the defendant. So this is one of the main reasons why they want this motion to be sealed. It's because it's going to reveal his personal information, medical information, and potentially any diagnoses that he may or may not have, or even confirmation of some diagnosis that the defense is claiming that he has. This goes on to say specifically the filing reveals mental health information about the defendant, including psychological, psychiatric, and neurological information and diagnoses of the defendant. Basically what I just said. I think I just spoke a little bit too fast there. The filing also reveals the nature and mental condition examinations already conducted and the type of examinations and testing the state seeks to perform, some in which is personally testing to which the defendant objects. And so this is, spoke a little bit further again, when it came to the defense's thoughts about his diagnoses, so they're going to confirm or maybe have an alternate opinion about those diagnoses, and the defendant objects to this. And so I think this is exactly what it is that we're going to be seeing or hearing about this undisclosed sealed hearing that's happening tomorrow, May 5th. So all that to say, it's not a plea deal. It's not anything like that. It is just specifically this aspect. And as far as the reasoning behind the extending for the rebuttal, they go on to say, I'm not sure if it's right here. It says the state has redacted the name of the psychology expert who is no longer working on the case. So they got a new psychology expert. That's probably another facet to this hearing. You have an objection from Bryan Kohberger about a psychological examination from a state expert, and the state also has changed their experts. Now, why have they changed it? I don't know. It could be a number of reasons. Pro-burgers are probably going to say something like, oh, maybe the psychologist agrees with them. What I'm thinking is it had to do with what it is that the defense is claiming now, right? Like, we knew they were going to come in and say that he had some sort of disorders. However, they weren't specific about it. Now we know that they're claiming autism, OCD, and some other things that could have prevented him from committing the crime. Some dexterity issues, I think is what they said, even though in their own writing they mentioned that the dexterity issues weren't an issue that had been around for quite some time. I think that's all this court's going to be about is, all right, who's your expert? How much time you're going to have? When are they going to allow, if they're going to allow that expert, which I don't see why they wouldn't. I'd have to ask a legal expert. Maybe I'm not sure if Chloe's in the building. Hopefully she is. But if she is, I'm not sure how or, the percentage wise goes, like, more than likely, not likely, least likely, 90% of the time, 10% of the time. I have no idea of how often it is that the state is allowed to examine the defendant. I would think it's probably more often than not, given the fact that the defense has made a claim. Now, the defense has made a claim of all of these diagnoses, and this is a reason for whether it's the penalty phase or whatever the case may be. It could be a double-edged sword now, because now they've made those claims, even though the state had said that they didn't have any intention on using any of the psychopath, sociopath terms, any of those things. Well, now these claims have been made. Now the state should be allowed to look at the defendant and verify their findings, and maybe perhaps have their own findings. It could work out not well for Bryan Kohberger. It could end up working out for the state. You know, it could be another shooting yourself in the foot type of situation by Bryan Kohberger and his defense team by making all these claims. But then again, when you have a weak case, when your case is weak and this is all you have, and mud is all you have to throw on the wall, you're going to throw it as much as you can, and that's what I see in this case. Nothing here that's going to, in my opinion, change anything as far as the August 11th trial, the start time, and or also the possible sentencing that he could face, it being the maximum sentencing. Let me know what you guys think. Let me know what you guys think in the comment section. Like, comment, subscribe, the whole 9 yards.